It's noon, and I wanted to thank you for coming today to talk with me about basics of estate planning. I'm Laura Bromlow, and we're going to be going through a webinar just telling you basics about why you should do estate planning and what you should be thinking about when you do approach this subject. So hopefully we'll cover all the basics today. I did want to let you know that in the chat of this, I have placed a notification with my email and my phone number, so that if you have any questions as it pertains to this presentation, or you have suggestions about future subjects that you would like me to present on, you can email me or give me a call. If you'd like to schedule a consultation, you can do that by either emailing or calling. So I wanted to let you know that's in the chat section. I'll also be showing the contact information at the end of the webinar. This webinar should last about an hour. Hopefully I'm going to get through it in an hour. It might be a tad longer than that. If you do have questions, please feel free to email me at the end. Just a little bit about me before I get into the bulk of this. And as I said, my name's Laura Bromlow. I am a certified elder law attorney through the National Elder Law Foundation, which means that I just have specialized knowledge in elder law, estate planning, Medicaid planning, VA pension planning, and special needs planning. I also practice in the areas of non-contested probates and guardianships, and I also help people with trust administration. So that's a little bit about what I do. I've been practicing in this area of estate planning and elder law since 2012, and am actively licensed in both California and Texas. I lived for about 13 years in Long Beach, California, and now am in Katy, Texas. I am, more importantly, a wife of 22 years and a mom to a beautiful 16-year-old daughter and 13-year-old son. I'm also an animal lover. You'll see my little furry friends on the right hand of your screen. I'm also a daughter and a sister-in-law, an aunt, a niece. So I have a large family that I also played various roles in. And that's important to you because when I'm sitting across the table or the desk from you talking about your estate plan, I want you to know that I'm going to give you the same advice that I would give to, my sister or my sister-in-law. And so you can know that I'm going to be advising you just like I would a family member. When I'm not with my family, I am out trying to be on the tennis court as much as possible. That is where I love being on the tennis court, love playing tennis. So a little bit about why I am in this practice area so that you'll understand why I'm so passionate about it is I come from, as we all do, an extended family as well. So I have aunts and uncles and cousins, and within my extended family, there seems to be a lot of cutting people off and a lot of miscommunication that leads to hurt feelings and broken relationships. And so one of these broken relationships, I won't tell you who in my family it happened to, but it was two brothers who had parents who were not good at communicating. In fact, they got into their older years not telling their kids or putting in writing what their plan would be if something ever happened to them, if they ever needed help. And so as the parents got older and they needed physical help and they needed help with their finances and help deciding where they were going to live and what kind of care they were going to get, these brothers disagreed as to what mom and dad would have wanted. And because mom and dad had never put it in writing, both brothers thought that they were sure that their point of view was what mom and dad's point of view would have been. And so this caused a lot of conflict. And eventually those brothers stopped talking to each other. Unfortunately, the parents passed, And, you know, several years later, the brother's still not talking. The older brother passed away. The relationship remained unreconciled. And unfortunately, those two brothers that grew up together went through the ups and downs of childhood together, and all of getting married and having kids and seeing each other through those things. They ended up, you know, not having a relationship at the end. So it was a very sad situation, one in which I can help other families prevent. And so that is my whole purpose in doing estate planning, is to help families build a way of communicating what their plan is, so that when and if and when the time comes, the family can come together and be a support for each other, rather than being torn apart because they have different opinions as to what mom and dad would have wanted. All right, so that's my why. Now, you're probably here today because you want to protect yourself, or there's something about your family that you want to protect. And so that is what is driving you to be here for this education today. When I talk to clients that come into my office, I've really narrowed it down to about 7 basic reasons that they come into my office. One of the concerns that clients bring to my mind is that they want to pass on their hard-earned wealth without government interference or court interference. So they want it to pass on how they want it, not how the court or how the government wants it to pass on. The second concern that I hear from my clients is that they want to avoid unnecessary taxes and fees. Third, they want to avoid going broke in a nursing home or having other crushing medical expenses, and they want to see what I can do about that. Fourth, clients will tell me that they want to protect their wealth from predators and creditors while my client is alive. So what can I do to protect my assets from my creditors? That's one concern clients will have. And related is, how can I protect my kids or my loved ones who I'm going to pass this on to from creditors and predators after I'm gone? And along with that, I will also hear, how do I protect my minor children from being raised by people that I don't want them to be raised by? Maybe there's a bad aunt in the family that I want to make sure my kid is never raised by. How do I ensure that happens? Or how do I make sure that it's my brother that gets to raise my kids if I'm not here? He's the one that has the values that most closely reflect mine. How do I make sure that happens? Sixth, I hear just the same concern of why I practice in this area is, how do I avoid my family members from being in conflict with each other when I'm gone? And then finally, how do I pass on my wisdom and my values and my life lessons to the following generations? So those are the 7 major client concerns that people have when they come into my office. They want to avoid court proceedings. They want to avoid taxes and fees as much as possible, avoid nursing home costs to the extent that they can. They don't want creditors and predators to come after their assets. They want asset protection for themselves. They don't want their family fighting over money, and they want to be able to pass on their wisdom and knowledge and value to the next generation. Now, I want to ask you, and I know this isn't interactive, but I want you to think about whether you have a plan or not. Here's just some statistics I came up with in a little bit of research that I did. But basically, only 32% of Americans have an estate plan. That means that there's close to, 70%, nearly 70% of Americans do not have an estate plan. That means there's a lot of people out there that have minor children that haven't named a guardian. There's a lot of people out there who don't have a plan, and so the state is going to have a plan for them and decide who's going to be making their decisions if they're unable to make them, and who's going to get their stuff when they die. Now, there's 2 primary reasons why people don't plan. And the first is that they just procrastinate. You know, by nature, we tend to be procrastinators. And so we don't feel like this is something that we don't want to face our own mortality. We don't want to talk about the subject of death or incapacity. It's not a fun subject. And so we're going to procrastinate. We're going to put that off later, until later. Why do today what we can do later on, right? So procrastination is the first reason. The second reason is that you don't know what you don't know. And so this is the one I'm going to hopefully help you nip in the bud today, where you're no longer going to have the excuse after you listen today of not knowing at least what you don't know. Today, you're going to know what you don't know, or you're going to at least know that there's a lot that you don't know about estate planning and that you should probably get assistance with. So I want to congratulate you. You are no longer fully procrastinating, at least. You have taken the first step of facing these tough topics that we're going to just glance over today, which is death and taxes. We're going to be talking about nursing home expenses a little bit. We're going to talk about how families can be torn apart potentially if you don't have a plan. We've talked about that a little bit. And if you do have a plan, there's a possibility that it may not work because maybe you've taken a shortcut or you haven't updated recently. So we're going to be talking about these difficult topics today, and I want to congratulate you for being willing to face them. All right, so here's what we're going to cover today. We're going to talk about will-based plans and trust-based plans. We're going to talk about why you need a knowledgeable attorney to help you with these things. And we're going to talk about what the most critical part of your estate plan is. So before we get started into the substantive part of this presentation, I'd like to do an exercise with you, and we're going to visualize the future. So if you will bear with me and go ahead and close your eyes for a moment. And as you close your eyes, I want you to imagine that you are surrounded by the people that you love. You're surrounded by your family, your closest friends, all your community that means so much to you. And you're doing something that you all enjoy doing together. And I want you to see yourselves doing that as a group and see the looks on everybody's faces. And I want you to feel the warmth and the connectedness that you have with the others. And now I want you to imagine that you're going to bed tonight. And as you wake up in the morning, you are unable to move. You're unable to handle your own affairs. You are now disabled. So you need help with your finances at this point. You may need help with your physical duties. You may need help making decisions. And I want you to look at those same people that you just were visualizing being around, and who in that group of people is stepping up to help you with your physical duties? Who is stepping forward to help you with your financial obligations, manage your finances, pay your bills for you? Who's stepping up to make decisions for you? And are those people the same people that you actually want doing those things? Are there more than one person stepping up for each role? Are they fighting about it? Or do they have a clear plan as to what your vision is for them? And I want you to notice the look on their faces and how they're feeling. Are they feeling like they know the next step? Or are they in chaos? Now I want you to imagine that you're going to bed tonight, and when it's time to wake up in the morning, you don't wake up. You have passed on and you're now in heaven, and you are looking down at your loved ones. And I'm asking the same questions. Who's stepping forward to take care of things? Is it the people that you want making those decisions? Do they know what to do? Or are they in chaos? Are they getting along well and supporting each other, or are they fighting? And then you can open your eyes. And now the reason I do that exercise is so that we can visualize the road ahead. I gave you two scenarios to picture for the future. One was that of incapacity, which is going to happen to probably 60 to 70% of us. And the second was death, and that is bound to happen to 100% of us listening in on this webinar. Everybody ends up dying at some point. So what do you want that road ahead to look like? Do you want it to be filled with, you know, pleasant, supportive family members, knowing what your plan is, or do you want them to kind of figure it out themselves? This is not the place that we want to be making that decision, right? So if you're already incapacitated or you're on the road to becoming incapacitated, it makes it very difficult. Now you're in a stressful situation and you're trying to make last minute decisions. You're not thinking rationally. We want you to start from your happy place. We want you to think about these things while you're with and surrounded by your loved one, while you're at peace, so that you can make rational decisions and decide how you really want that road ahead to look. Now, if I asked you, what is the most important thing to you? I guarantee most of you would not mention your IRA or your investment accounts. Most of you are going to say the most important things in my life are my family or my friends, my experiences, my community, my health, right? This is what my clients believe is the most important things in their life. And that's why I tend to take a holistic approach to estate planning. I do not believe that this is all about planning for your assets and what's going to happen to your assets. I believe this is how your assets and how your decisions impact your family. I want to make sure that your plan reflects your core values and that it reflects what wisdom you have learned throughout your life, that it's impacting your community in the way that you want. And of course, we are going to take care of your finances as well. So I approach it holistically. Now, there's 5 reasons that plans tend to fail for people. And the first is that they have poor documents. A set of poor documents is going to be a disaster. So a lot of people will try to do it yourselves, and they'll go online and do a document preparation service. And those will end up being poor documents. And their plan, they think they've got a good plan, but when implemented, it does not turn out the way that they wanted. The second is no nursing home protection. So their plan does not take into account what it would look like if they end up needing a nursing home. Failing to fund, if a person has a revocable living trust and they fail to fund that trust, it can make their plan completely fail. We'll talk more about that. And then failing to update their documents is a big reason that plans will end up failing. So, you know, we'll have a client who did their documents when their children were first born and it was on their mind, and then they don't think about it for many, many years, and now their children are adults, and if something happens, their plan may not be up to date, and so it's not going to work the way they want it to. And finally, not having remarriage protection in your plan. So a lot of times a couple will be married for many, many years, 40 years. They'll do a plan, and then one of them will pass away, and the surviving spouse finds somebody else to spend the remainder of their life with, and that plan did not have any protection for that surviving spouse getting remarried, and the new spouse may end up with a portion of the estate. So that can cause a plan to fail as well. Now I'm going to take you through a fictional client story to kind of show you the difference between a will-based plan and a trust-based plan, and how these things will actually work out in real life. And so my fictional clients here are Bob and Sue Smith. Now, Bob and Sue Smith have been married for many years. We're going to say 40 years. They've got 2 kids together. Sue was a stay-at-home mom for her life, and she raised the kids. So she put all her time and effort into raising the children and making sure that they knew what Bob and Sue's values were and instilling those values into the kids. Bob was an accountant, and he worked hard through the years to support his family. And now he's at the age where he's getting ready to retire. And so that's where our story begins. Now, the main reason for Bob and Sue's why they do everything is Josh and Kate, their kids. Now, Kate was the firstborn child, and she did everything exactly the way, by the book. And so, if you recall, or if you're in that area now of life where your firstborn was born and you got all the children's raising kids books and how you're supposed to raise them, how to discipline, how to feed them, all those things, Kate did everything exactly by the book. And she ended up being a straight A student, and then she went right into a 4-year college, graduated in 3.5 years with a great degree, went on to get her master's, and now she's a professional. She's married with kids of her own, and she has just done it perfectly. Josh was not that perfect child. And Josh is, he marches to the beat of his own drum. He does things his own way. He is not going to, follow the rules precisely. He's going to do it his own way. Josh may have an issue. Josh may be a kid who has an issue with addiction, gambling, alcohol, something like that. Or he just may have a failure to launch problem, okay? So either way you want to think about it, Josh is that kid who's less than perfect. Kate's that perfect child. Regardless, what do you think? Bob and Sue, do you think they love one of these kids more than the other? Of course not. If you have kids, you know that they do not love either one of these kids more than the other. They love them both the same amount. They just have to treat them differently. And so keep that in mind as we go through our story. Now, as Bob's retiring, he makes a to-do list with Sue, and they sit down one Saturday and they say, yeah, let's plan a vacation. Let's start an exercise program. Make sure we get to visit the grandkids. Oh, you know what? We never did create a will. We need to do that. And then also let's get some volunteering done. And so number 4, they've got to create a will. But let's take a step back. Before they decide to create a will, let's really take a look at what their options are when it comes to estate planning. They have many options, really. They could have a plan to spend it all. They could have a plan to die intestate. They could try to do online document preparation themselves. They could try to put everything, all of their assets, into joint title with their kids to make sure it passes on. They could just make sure that everything that they own has a beneficiary designation. They could do a will, and they could do a revocable living trust. So they've got lots of options of what they could do. Let's take a look at these options real closely. First of all, their spend it all option. This is a wonderful, wonderful option, if only it would work. We all work super hard for our money, and it would make me so happy to see my mom be able to spend every dime that she worked so hard to earn throughout her life. If she could spend it all on herself and make herself happy. Same with my clients, they've all worked hard, and if they could spend every last dime making themselves happy, that would be wonderful. The problem with it is that we don't have what we need, which is a magic ball, right? We don't know what the future is going to hold. We don't know any unexpected medical expenses that might come up, emergencies that might come up and cost money. And so we don't know how to dole out the money to make sure it's all spent by the time on the day we die. That's the problem with spending it all. Their second option, which was to die intestate, means they can just say, hey, to heck with it, I'm not going to do any planning, and that's called dying intestate. Well, when you die without a plan, the state has a plan for you. So whether you're in California or Texas or another state, the state of California, the state of Texas has a plan for you, and it may not be what you think it should be. So if you don't have a plan, the state's law is going to decide who gets your stuff. So this becomes really important in the case of second marriages where you had children from the first marriages, second or third marriages, either way, blended families. It becomes important if you've ever had a child that was adopted, but your parental rights were never severed. It's important if you had children, you know, and then got married. So all of these things, or if you don't have children, it can be really important too. Online document service is another option that Bob and Sue had. They could go online, I'm not going to mention any company names, and fill out answer some questions and have the online document preparation service prepare their documents for them. The problem with this is they don't know the consequences of the answers that are being asked of them. I actually went online somewhat recently and did one of these services myself to see what I would get. I paid the money, answered the questions, and even as I'm answering this, having done estate planning for the last 8 to 9 years, I was unsure what that document preparation service was going to pump out based on the question and the answer that was being offered to me. So even me as an attorney was unsure whether they would populate what I really wanted. So I do not suggest that you use these services. Another option that clients will think that they have is to put everything in joint tenancy. So Bob and Sue might say, well, we want everything to go to the kids equally, so why don't we just add them to all of our bank accounts and add them to our house, and then we all own it equally, and then when we die, they just get to take it over. Okay, here's the problem with putting things in joint tenancy because you want it to pass to the joint owner. The problem is that as soon as you add them to title, they are now an owner, which means that that asset is subject to their whims. If they want to go out and spend the money from the account, they can do it. Okay, let's say that they don't do that. You trust them not to do that. But it's also subject to their creditors and their divorce, potentially. Okay, so let's say that Bob and Sue add Josh to their bank account. Josh goes out and he gets in a car accident, and now he is responsible for injuring somebody. That injured party sues him and gets a judgment against him, and guess now who has access to the account besides Josh? The injured party who has a judgment now also has access to that. So that's the problem with joint tenancy. Bob and Sue might say, well, they don't have to own it now while I'm alive, but I'll just add them as a beneficiary. So the problem with this is a few. If you have minor children, it's a problem because if you have your minor child as a beneficiary on an account, if you die and it's supposed to go to a minor child, there's no way to get it to a minor child. They're not legally allowed to have money in their own name. So somebody has to go to court to get access to that money to manage it on behalf of the minor child. So that's one problem. So then you say, okay, well, I'll just add my brother as the beneficiary to that account and let him know that he's supposed to use it for my minor child. Problem with that is the same problem I just told you about joint tenancy, which is now if I die and my brother's the beneficiary, now that asset belongs to my brother. And if he goes out and he gets in a car accident, now all of those assets that were meant for my minor child are going to my brother's debt, okay, or his divorce potentially. So those are two big reasons. The other is that you're foregoing a multitude of benefits of having it possibly go through a lifetime trust or some other things that we'll be talking about later on. Another problem with beneficiary designation is oftentimes I will, see clients who name a beneficiary, but that beneficiary passes before the client does, and they forget to update their beneficiaries. And so now there's no live beneficiary when my client passes. And so now we're going through probate court anyway. So Bob and Sue could create a will, and we're going to be talking about what that looks like, or they could create a revocable living trust, and we're going to talk about that as well. Okay, so Bob and Sue decide that they're going to create a will. So Bob says, well, Sue, you know, we've been wanting to do this will for a long time. I know that's what we need to do. I play golf every Sunday with these guys, and I know that Joe has a son who's an attorney. I'm sure he can whip us up a will and we can sign it and be on our way and we'll be good to go. And so that's what Bob does. He goes to Joe and he says, hey, Joe, give me your son's name. And so Joe gives Bob Joey Jr.'s name, and they go in and see Joey Jr., and Joey Jr. creates a will for them, and they think they're all set to go. The problem was that Joey Jr. was not an estate planning attorney. He was a general practice attorney, and he did mostly criminal law, actually. And so when he did their will, you know, he didn't know all the options to give them. And he said, well, they want a will. That's what I'm going to do. Created a will, said, okay, Bob, if you die, everything goes to Sue. Sue, if you die, everything goes to Bob. When you're both gone, everything goes to the kids equally. We're done with it, sign it, and we're on our way. So let's talk about how the will works when certain things happen. So now, a week later, because Bob has, you know, started this rigid exercise program because now he's retired and he's got time on his hands, Bob ends up having a stroke soon after they put that will into place. And so what do you think that the will does for Bob after he has a stroke? He's still alive, but now he is incapacitated. He can't make his own decisions. He needs help with daily activities, and, you know, who's going to help him? What does the will do? Who's going to handle Bill's affairs? Does the will say? The will doesn't say who's going to handle his affairs. All the will does is says who's going to get his stuff when he dies. So since he can't make his own decisions anymore, somebody's going to have to go to court to get a guardianship over Bob to make decisions for him. There are two kinds of guardianship. There's a guardianship of the estate and a guardianship of the person. And so to get access to Bob's money, if Sue is not on the account, she's going to need a guardianship to get access to it. Any IRAs or 401ks that Bob has that are in his name, she's going to have a guardianship to get access to manage those 401ks or IRAs. A guardianship is a court process designed to protect those who are mentally disabled, and it strips the ward of certain rights and gives them to someone else. So what we're saying is Sue's going to court and saying, Bob can't do these things, strip his rights from him and give them to me. Give me his rights to exercise on his behalf. And so whether it's a guardianship of the estate, exercising ownership and not ownership, but exercising rights and control over Bob's assets, or whether it's guardianship of the person exercising Bob's rights to make his decision as to health care, to where he's going to live, and those kinds of things. Now, guardianship is not fun for anyone. It's humiliating for Bob in this circumstance. The court's in control as to whether Sue is actually going to be appointed as the guardian, and it's time consuming, personal information is disclosed, and it's expensive. So a guardianship on average can cost about $10,000 annually because of all the reports that need to be made, attorney's fees, accounting fees, etc. So we want to avoid guardianship if possible. Now, that's not Sue's only problem, though. Once she gets guardianship, now she's got to be concerned about the fact that Bob is disabled, and how is she going to take care of him financially? So we're going to talk a little bit about long-term care expenses. Long-term care can take the form of many things. So it can be in-home care, it can be adult daycare, it could be assisted living, or it can be a nursing home. 70% of people over the age of 65 are going to need long-term care at some point. And I believe it's even, well, anyway, 70% of those over 65 are going to need it. That's right. And then that's through the U.S. Department of Health and Human Services said that in a 2018 study. So how is Sue going to pay for these long-term care costs? Well, there's really only 4 ways she can pay. They can use their own money, Bob and Sue's money, right? Of course. She can, hopefully they got long-term care insurance before he was disabled. And if that's the case, then long-term care insurance can cover some of it. A lot of people think Medicare is going to cover it, but Medicare is really only medical insurance. And so it only covers very general medical expenses, and it only covers a limited time of long-term care needs. So up to 90 days is going to cover for care, but beyond that, that's long-term care, and Medicare doesn't cover it. And the other option would be to use some needs-based public benefits such as Medicaid or the VA pension benefit. So Medicaid is a joint federal and state government program that will pay for most long-term medical expenses in America. So this really only comes into play in California and in Texas. Nursing home expenses can be paid through Medicaid, or in California it's called Medi-Cal. If you qualify. So you have to meet an asset test, meaning you don't have a certain amount of assets over a certain amount, and you have to meet a limited income test as well. So you can't have over a certain income level. The VA pension benefit is also a needs-based benefit for wartime vets. And they also has an asset and income limit on those. So long-term care can be paid using your own money, long-term care insurance, a little bit of Medicare, but not much, and then becoming eligible for public benefits, or a combination of all of the above. And we do this kind of planning. So when it comes to public benefits, at my law firm, we do plan for you to be eligible for Medicaid. If you're not currently eligible, there are ways to make you eligible in the future when you may need it. And there are things that need to be included in your basic estate planning documents that if you ever did need Medicaid, or you needed a nursing home, so you wanted to be able to rely on Medicaid, you need to have certain things in your underlying documents. And I make sure that those are there for all of my clients. It's important that you understand the cost of long-term care. I really didn't go into it, but long-term care, can be in-home care, which is the most expensive, nursing home, assisted living, and daycare. So nursing home costs can cost around $100,000 on average in the United States. So you can see how quickly it would eat up your hard-earned assets. I'm going to tell you just a quick story. I'm going to try to make it quick, about my Aunt Julie, who taught me a lesson about Medicaid and Medicaid planning. My Aunt Julie lived to be 102 years old. Here's a picture of her with me and my siblings. Aunt Julie and Uncle George lived through the Depression. They were very careful with their money. They saved every bit they could. They even burned their trash, which I know was against the law, but they burned their trash so they didn't have to pay for waste service. They grew their own fruits and vegetables and would barter with other people who did the same thing. They saved enough money to build their own little house. It was a 1-bedroom home because they never had children of their own. Anyway, Uncle George died, and Aunt Julie ended up living in that home for a very long time by herself. And my dad, who was the closest to a son that she didn't have any children, would go over once or twice a week, knock on the door, bring her groceries. And he did that religiously. And one day he went over and knocked on the door and she would not answer. So he knocked on all the windows around the house. Finally, he broke into the house because she was not answering, yet her car was in the driveway. So he knew that she was there. He broke in and found her at the bottom of the steps in the basement of her house, just unconscious. So she did what so many people at an older age end up doing, and this was in her 90s, which is having a fall, which begins their long-term care journey, right? So from there, she ends up right from her home into an assisted living facility. My dad got power of attorney over her assets. So he was the agent under a power of attorney for her, was able to manage all of her assets for her and pay for the assisted living facility. Really made that money last. She ended up in a nursing home, at which time he kept paying for her nursing home care as her agent. He kept paying for that. And until she ran out of money. She ran completely out of money. And at that time, that was like 2 or 3 years in, my dad applied for Medicaid. She was eligible for Medicaid. Then Medicaid took over the payment. She's in the same exact facility that she was when he was private paying. Now she's in the same facility, but Medicaid's paying the bill. And the last time I went to see Aunt Julie, which I didn't get to see her very much because I was living out of town. This was back in St. Louis and I was in California. The last time I went to see her, it was around Christmas time. You know, I got to tell her some stories and rub her little hands and feed her some vanilla ice cream, which she loved so much. And she was just happy. You know, she couldn't talk, but I could tell those little things brought a smile to her face. And what I was about to learn as she was passing away was how Medicaid planning could have helped my dad with her. So had he done some planning in advance when she just went into the assisted living facility, we could have put some money away in a special trust that when she entered the nursing home, she would have been eligible right away for Medicaid. Medicaid would have started paying the bill from day one in the nursing home. Dad would have had the money over here in this pile that had been protected, and he would have been able to pay for an additional caregiver to go into the nursing home to visit with her, to tell her stories, to give her a massage, to feed her vanilla ice cream, whatever it was going to improve her quality of life at that time. So that's a little bit about my Aunt Julie and how Medicaid planning can help. So we're going to go back to Bob and Sue. This says Bill, but it should be Bob. So when Bob passes away, what's going to happen? What does the will-based plan do for him? Now the will comes into play, right? Now Sue is going to take that will and she's going to go to court to go through a probate process. Probate is a court proceeding that will pass title for real and personal property from the deceased person, Bob in this case, to their beneficiaries. Now, the probate process is, in Texas, it's very easy. In California, it's very complicated and very expensive. In California, it can cost tens of thousands of dollars to go through a probate. So there's a reason to not do a will-based plan right there, that you want to avoid all those costs. In Texas, it can be a very cost-efficient process, pretty timely, pretty quick. We have an easy probate process in Texas. Either way, you have to admit the will to probate to the court. The court has to accept the will as a valid will. The court has to then appoint an executor, resolve any disputes among the beneficiaries, pay creditors. That's the very first thing that the court's going to do after admitting the will and appointing an executor, is they want to make sure that notices get sent out to creditors and that notice is published to the public at large about this estate. There has to be an inventory and appraisal of all the assets presented to the court. And then there's a change in the title to the assets, and then finally a distribution of the estate. So the probate process, has to go through all those steps, whether you're in California, which is going to take a lot of money and time, or whether you're in Texas, which is going to be short time and less money, potentially very quick. Either way, the problem with the probate is that it's public. So if you didn't want to avoid it for the expense, because it's an easy one in Texas, the other reason you may want to avoid it is that it's a public proceeding. And so when you take a will to be probated, it gets published publicly, and anybody can now find that will. I'm just showing you an example of Jackie Onassis, her will that you can find online because she had it published. You can also find Barbara Bush's will online and see that. So there's lots of public, famous people that have public wills because they had to go through probate. Now here's what Bob's plan looks like. Since he got a will-based plan, he has already paid $100,000 in fees through the probate, which in Texas was very cheap. In California would have been much more expensive. He's paid $90,000 in long-term care costs, and his guardianship costs at least $10,000. So he's actually paid more than $100,000 for his estate plan, but he's left Sue with almost $1.5 million. So here's the summary of his plan. It was expensive, time consuming. There was no protection from guardianship, nursing home costs, or probate. And we didn't even talk about how he passes on his values or life experiences. Now there's other worries after Bob is gone. And those are, what if his wife gets remarried or there's family feuds? What if there's lawsuits and creditor claims against his wife? And what about her nursing home expenses? So let's say that Bob passes, Sue's lonely now. She gets married to the guy next door, Steve, who Bob really never liked and really hated his kids. And Steve is now broke because his own wife had an illness that broke them. So now Sue is with the neighbor, Steve, who Bob never liked and is super poor. Let's first talk about lawsuits and nursing home expenses. Now, who's going to pay Sue's nursing home expenses if she needs them, right? Because Bob left everything to Sue, and so now she's going to have to pay it. And what about if Sue gets in that car accident and now all of her assets are subject to the injured creditor? So Sue lives 10 more years, and so she's got almost $1.5 million that's going to grow over the next 10 years. And she eventually, though, develops Alzheimer's. She has to be placed in a nursing home herself because she's now unable to handle her own affairs. The average stay here in America at a nursing home is 3 years, and the annual cost in Texas is $77,000. So at 3 years for Sue in this nursing home, it's going to end up costing her $231,000 because of this Alzheimer's. And they didn't do any planning for the nursing home costs. So the first question is, now that Sue can't make her own decisions, who's going to handle her affairs? Well, remember, she's got a will-based plan, and so somebody has to go to court to get a guardianship over her to make decisions for her. So what's going to be the problem this time is that it's going to be between these two kids of who should have control over Sue's decisions. Josh is going to say, you don't want to listen to Kate. He's going to get all dressed up to go to court, and he's going to present himself very nicely to the court and say, I'm the one that should be in charge of my mom's affairs because I'm the good kid. You don't want to listen to Kate. She's not a good kid. And she's going to do the same. And they're both going to be fighting for who should be in charge of Sue's decisions, who should be appointed as the guardian. And so the court is going to get very tired of hearing the arguments. And it always reminds me of me and my kids. And so I'm, here's me and the kids going, so help me, I'm going to pull this car over if you two don't stop arguing. And so that's what Josh and Kate look like to the court, right? They're arguing and the court says, I'm going to pull this car over, and instead of appointing either one of you, I'm appointing an independent third-party guardian, which is going to cost your estate money. So now Sue is having to pay for the independent third-party guardian on top of the guardianship costs of $10,000 a year. And neither Josh nor Kate are in charge of making her decisions. Now, I'm sure that that Sue probably had thoughts about which child she would prefer making decisions for her. And she probably would prefer a child over an independent third-party guardian that she does not know. So now when Sue passes away, there is going to be a final probate of her will. So she's going to have to go through the same probate procedure that Bob had gone through. And what about death taxes? Well, luckily, the estate tax exemption amount today is over $11.5 million per person. So for a couple, that equates to over $23 million per couple. So they don't have to worry about an estate tax because the estate tax exemption is so high. If you do have a non-US citizen spouse, there could be some other issues because the exemption amount is much, much, much lower. And it's good to keep in mind that the estate tax exemption amount is likely to go down under the new administration or from administration to administration. We never know what it's going to be from one president to the next. So as I'm looking at Bob and Sue's estate plan and we're remembering them, how do you think people are going to remember them? First of all, they're not remembering any of their stories. They're only remembering having to go through probate and all these processes through the court. And look at the cost that Bob and Sue have ended up with through their will-based plan. So here they've ended up spending almost $300,000 with guardianship costs, nursing home costs, probate fees, etc. And after Sue passes away, there's also other concerns that Bob and Sue have. So there's three worries that parents have for when they pass away: the financial maturity of their children or loved ones that they're leaving money to. What about lawsuits and creditors of those loved ones that they're leaving money to, and the divorce of the loved ones? So let's talk about financial maturity, which is the first concern of most parents. Are these kids ready to each receive a six-figure inheritance? Are they going to go out on a shopping spree? What are they going to end up doing with this money? Financial maturity. Second is lawsuits and creditor claims. So Josh, ends up spending his money on a very expensive sports car, gets in an auto accident, and then his money that his mom and dad left him is all subject to these creditors through the auto accident, or perhaps he gets in tax arrears and now it's all subject to taxes. And finally, let's just take Kate, for example. She gets married and the guy she ends up marrying is not the best match for her. She didn't know that she was supposed to handle her money in a certain way, and so it gets mixed with marital property and now is considered community property. And in the case that they end up getting divorced, her husband Brad would end up getting half of the money. So here's a summary of Bob and Sue's plan. There was no protection from the nursing home costs or guardianship or probate. There was no protection when Sue decided to get remarried to Steve. There was no protection if Kate ends up getting divorced from Brad. There was no protection for the children, like Josh, if he gets in a car accident or owes the IRS money. And finally, they never left anything about their values or life stories. So there's got to be a better way, and yes, there is. And so we're going to give them a do-over. We're going to start over. And this time we're going to give them a living trust, a revocable living trust. So what is that and how does it work? Well, a trust is really just a three-party contract. The three parties are the trustors, the trustees, and the beneficiaries. The trustor is the person who creates the trust and transfers their assets into the trust. The trustee is the person who manages those assets for the benefit of the third party, which is the beneficiaries. The beneficiaries are the people who have the benefit of what's in the trust, of the assets that are in the trust. So when Bob and Sue come in to do a revocable living trust with me, they are going to have total control. They are going to be in all three positions. They are going to be the trustors, the trustees, and the beneficiaries. So they're going to create it, they're going to control it, and they're going to get the benefit of what's in the trust. So it's going to be business as usual for them. They're going to be able to amend or revoke their trust as they want. They can still buy and sell and refinance assets. They're not going to have any new tax requirements, no income tax forms that are required in addition to what they're doing. Nothing for tax purposes changes, and there's no change in the property tax bills either. So you may be asking yourself then, what's so important about a trust if it doesn't change anything? Well, it is a standby device. It is protection in case you become disabled or die. There's no court involvement if you do have a fully funded trust, and it's going to protect your spouse, your children, and your grandchildren or your loved ones. The magic is in how title is held to your assets. So what is title? Let's say I've got this book and it belongs to Aunt Julie. If Aunt Julie owns this book and she becomes unable to make decisions, so she can no longer decide who to give it to or who can sell it or use it as collateral for a loan, then somebody has to take that book. They can't take the book. They have to go to court to ask the court for permission to take that book and either sell it, use it as collateral for a loan, or give it away to somebody else. They want to take care of Aunt Julie. This is a special book. If they wanted to use it as collateral for a loan, they have to get court's permission, okay? Because Aunt Julie owns the book. But if Aunt Julie's living trust owns the book, now something happens to Aunt Julie. She becomes disabled, and I can go, oh, Aunt Julie's trust owns this book. Well, let me look at the trust. Now I go to the trust document itself. I open it up, and it says, if Aunt Julie's disabled, Laura is the successor trustee. I've got the trust document that says that now I'm stepping into the role of trustee, and so now I have permission to take that book without court involvement, without anybody else having to give me permission. So what we're going to do is we're going to transfer all of your assets to the trust. All your joint property, the wife's property, and the husband's property is all going to be transferred into the trust. And now we're going to take a look at how it works differently through these different time periods. So when Bob has a stroke, now we have a trust that owns all of his assets. We've got a fully funded trust. So if somebody needs to make decisions or manage the money, we don't have to go to court to get a guardianship anymore because they have direct access to the assets through the trust document. So we get to avoid the guardianship process. And what about when he dies? We don't have to probate anything. We've got a trust document that says, okay, Bob's gone. This is the successor trustee that can manage the trust assets. And trustee, this is who I want you to distribute the money to. Okay, now we're going to distribute it to Sue because that's what the trust says. We don't have to get the court to do anything because it's owned by the trust. So can the Smiths keep it in the family after Bob dies? Can we keep it away from Steve this time? We absolutely can. What we can do in the trust document is we can put terms that say Sue must enter into a prenuptial agreement as a condition to continue managing the trust assets if she remarries. We can also say, you know what, these assets of Bob's, they can't pass down to non-family members. We have to keep it in, it has to remain in the family. So we can put those provisions in that keeps it out of Steve's estate. Now, we can also protect a portion of the family's assets from liability. So in the case that Sue ends up in a car accident, the money that belonged, the portion of the money that belonged to Bob is not going to be used to pay off those creditors. Same with nursing home expenses. And not only nursing home expenses, but we're going to have provisions that say Kate takes over as the trustee to manage the assets for Sue when she becomes disabled with Alzheimer's. We're going to have done some Medicaid planning so that we can make sure, to the extent possible, we can avoid this $231,000 in nursing home expenses. So without a Medicaid protection trust, nursing home costs, or with one, nursing home costs can be eliminated. Now this is kind of special planning. This is beyond basics, but if you want to look at something like this, we can definitely talk about that. So when Sue passes away, there's no probate of the assets. Kate takes over as successor trustee, follows the directions of the trust document, which says half goes to each her and Josh. We're also going to have a way to include Sue's wisdom and life stories, make sure that those are preserved for future generations. I'm going to be talking about that in just a couple minutes. So when Bob and Sue are gone, we have $750,000 that is going to Josh and $750,000 going to Kate. So let's talk about how it should go to Josh and Kate. Now we're looking at both Bob and Sue are gone. Here's their trust. Everything was in the trust. And now it's passing to Josh and Kate equally. Now this trust is going to be, I want you to think of it as a tube of toothpaste. So if I squeeze it out, I can't get it back in. Once I've squeezed it out, I can't get it back in. So I want to be very careful who I leave in charge of this trust, right? I'm going to consider leaving assets in trust both for Josh and for Kate, but for very different reasons, because remember, they're very different people. So the first thing is a lifetime trust. For Kate, I'm going to consider leaving her assets in a lifetime trust in which she can act as her own trustee, but I'm going to have certain restrictions about how she can distribute money from that trust to herself. They're not going to be super restrictive, but they're going to be restrictive enough to give her some asset protection and divorce protection. For Josh, I'm going to consider a spendthrift trust because I don't want him to be in charge of it because he either has some issues with, failure to launch. He's not good with investments. I'm going to appoint an independent trustee, probably not Kate, because I don't want to create issues between the two of them. And I'm going to put restrictions on how distributions can be made to Josh as well for his health, education, maintenance, and support. This is going to protect him from lawsuits, from his own bad decisions, and from his divorce if he ever has one. If I had a loved one that had special needs and relies on SSI or Medicaid, I am going to consider leaving that person's inheritance in a special needs trust. So these are the benefits of a revocable living trust. We can avoid guardianships, probates, we can help with nursing home costs, death taxes, we can leave behind values, we can protect Kate from her divorce and Josh from his lawsuit. So what is your action plan if you want to get started? What do you need to do? How do you make it happen? And when should you get started? We're going to talk about that a little bit. So here's my process of getting started. The first thing you would do is, after we finish this webinar, please feel free to email me if you would like to set up a consultation, which I call a family wealth planning session. You can either email me or call me to set that up. We would have that initial consultation, and during that consultation, we'll talk about all kinds of things. We'll design your plan. Then I would go create the documents. I would review the documents with you. We would then have the signing of the documents, and then the final step would be for you to pick up your binder and your documents, and at that time you have the option to do a family legacy interview, which is that part of this plan that is leaving your stories and values and all that behind to the next generation. So your portfolio is going to look like this. You're going to have a binder, and in that binder are all your documents, explanation of documents, title transfer instructions, what I'm going to help you with that as well. You're going to have a flash drive with all of your signed documents on it, and you're going to have a family legacy interview either saved on your flash drive or maybe a written one if you want that. So the documents that will be included in your portfolio will be a revocable living trust or a will, depending on what kind of plan you want. You'll have a pour-over will if you have a trust. You'll have a property power of attorney, your healthcare documents, and your asset lists and deeds to properties. The family legacy interview. This is that part that's the last step when you come in to pick up your binder. I offer my clients, free of additional charge, this opportunity to sit down with me and either audio record or visually record an interview in which we will have previously agreed upon questions that I will ask you and you will answer to tell future generations. If you don't want to do the family legacy interview, I encourage you to figure out another way to pass on your values, stories, and advice. Here's some other thoughts of things that can either be included in your interview or other ways that you can pass on things to the next generation. So we can have in there family stories, advice to unborn descendants. You can leave words of wisdom. Sometimes people like to write a love letter to their family, leaving heirlooms and pictures. Of course, scrapbooking is another great way. And sometimes, you know, like there's a special Bible or other holy book or verses from that you want to leave behind. So I have 3 levels of planning that I do, and the very first step is to get you more financially organized than you've ever been before, and we do this through my questionnaire, which I call an inventory and assessment. It's a family inventory and assessment, and it's got a lot of questions, but mostly you're just getting financially organized before you come in to the consultation. The other thing that we make sure you do is that you're making empowered and informed decisions about your estate planning. So I want to make sure you know all of your options, have all of your choices in front of you. And then I'm going to offer you 3 levels of planning for your basic estate planning. We have 3 levels. There's a will-based plan, there's a trust-based plan, and then there's a trust-based plan with me handling the funding. So those are the 3 levels. They range in price from $2,500 to $7,500 on average, depending on what choices you make within your plans. And this is going to give you the certainty, the peace of mind to know that your family is protected if and when your plan is needed. They have a set of documents that are actually going to work. They also have access to an attorney that is going to help them, because I plan on being your family's attorney for life and your go-to. So I want to help them through that process. The other thing that I do in addition to this basic estate planning, which is the 3 levels, I also do other kinds of special planning. So I do special needs planning. I can help with asset protection. I can do Medicaid and VA improved pension planning, and I can help you with retirement inheritance trusts. Now, it's really important to remember that once you put a plan in place, it's not a one and done thing. You need to update your documents. So you need to review your plan yearly, at least on your own. So I expect my clients to, when it's tax time, remember, oh, I've got assets that I need to pay taxes on. I may want to look at my estate planning documents now too. That's a good time of year to remember. Update them also when needed. So if there's a life-changing event or if there's a change in the law that you hear about, it's time to update. So come in, talk to your attorney, and update them. And then we want to make sure that you have an ongoing long-term relationship with me. So I'm going to keep you updated newsletter. I'm going to communicate with you. I also have VIP membership levels that I offer my clients, so you can renew yearly a membership with my firm and get access to me, you know, free of additional charge for certain things. Now, for non-VIP clients, I meet with them every 3 years, free of additional charge, to review their plan and make sure it doesn't need any updates. If it needs updates, then we'll do that at an hourly basis or a flat fee basis, depending on what it is. But I always tell clients ahead of time what their cost is going to be. I do not like surprises in money for clients. So I'm always trying to be very, open with that. And then VIP memberships I kind of talked about. And if you want more information about that, I can tell you about that at the time. So now I want you to think about all the things we talked about, all the concerns that were raised through this presentation. What's the most important part of your estate plan? And have that in mind. You know, so for me, it might be making sure my kids don't fight when I leave, making sure that it's very clear. Well, what is the most important part of your plan is whatever is most important to you. That's the thing that needs to be reflected in your plan. So please make sure that that gets in your plan. And the only way to really do that is with a knowledgeable estate planning attorney, someone who is patient with you, will take you through all of your options and make sure that it's done properly. Now, I want to say a final word about funding. Remember, this bucket that's empty, it's not going to do anything. If this is your trust bucket and you don't have anything in it, then your trust is not governing anything. Your trust only governs what it owns. So we have to make sure that it is fully funded for this to work properly. Now, if you would like to proceed, you can call my office. I've got the phone number here. Schedule a family wealth planning session. You can also email me. You're going to then complete the family wealth inventory and assessment, choose one of the 3 levels of planning, and then sign a representation agreement and make your payment, and then we'll schedule your next meetings. So for being here today, I have a couple gifts. Just for listening in on this webinar, I'd like to offer the family wealth planning session free of charge. This is a gift of $700 to $900 normally. My hourly rate is $350, and the family wealth planning session can take up to 2 hours. If you have a plan in place and reviewing that plan, and you want me to review it, that can cost around $900 normally, because it's going to take me some time to review somebody else's work. The other gift that I'd like to offer you today is that if you will go ahead and sign up today for your family wealth planning session, I will give you $300 off of your trust or wealth plan. And so what you can expect when you come in to meet with me is a 2-hour session. So at the beginning, what I'm going to do is I'm going to go through with you what would happen as things currently stand. So either you don't have a plan or you do have a plan, how it would work out if you became incapacitated or died as of this moment. Then we're going to talk about what you like about that and what you don't like about what would currently happen. We'll talk about how we would change the things that you don't like and how we keep what you do like. And then we'll see if we're a good fit. I'll present to you the 3 levels of planning. You'll choose which one works best for you. If you think we're a good fit and you like one of the 3 levels of planning, then we can proceed into the design phase of the meeting, which means that we're going to sit and talk about who's going to play what role in your plan and get all of those things hashed out. Who's going to get money when you die, who's going to have control if you're incapacitated, how you want them to have either control or ownership of the assets, and make sure you know all your options so that you can be well informed and you can feel empowered that you've made the best decisions for your family. And that can take up to 2 hours. So at the end of that 2-hour session, I would present you with the representation agreement. We would go through that. You would sign it. You would pay half of your fee up front. And then we would schedule the next meetings. The next meetings would be a document review meeting, and then a signing meeting, and then a binder pickup and interview meeting, okay? So if you do want to follow up, schedule anything, or if you've got any questions about my webinar presentation, or if you've got any suggestions for future presentations, please feel free to get a hold of me here at this phone number or at this email address, and I'd be happy to answer any of your questions. And I love suggestions on future presentations. So anyway, I thank you all so much for joining me today. I hope this information was helpful, and I do hope that it provides an impetus to just move to the next step and get this done for your family. You all have a great rest of the day. I am sorry that we went a little bit over, but we will, I'm here if you've got any questions. Okay, thank you so much.